It's me once again, your favorite legal scholar. I am Item Basi, and today we'll be continuing from where we stopped last week, where we were able to see one of the legal frameworks of outer space, or the legal frameworks of international space law, which is the Outer Space Treaty. So, continuing from there, as seen on the screen, we'll be discussing the rest of them, which include the Moon Agreement, the Rescue Agreement, the Liability Convention, and of course, the Registration Convention. So I'll move forward again. Now, what exactly is the Moon Agreement all about? Okay, formally called agreements governing the activities of states on the moon and celestial bodies. It has a few contents which are going to be talked about briefly before we move forward. So these are the following. The following are the contents of the Moon Agreement. As seen on the screen, we have number one, which is peaceful use. It says here that the moon and other celestial bodies can only be used for peaceful purposes. Okay, so anything that can cause harm to individuals or to state parties by reason of another state party's use of the moon should be prohibited, should be proscribed, should be stopped by any means possible. Even the Outer Space Treaty stipulates that moon should only be used for peaceful purposes and not to harm other nations or even space itself. The second one here is no military bases. This one cannot be overemphasized. When I talked about the framework of international space law, I did mention the history, and we talked about Russia and United States juggling for positions earlier on as regards space. But now this particular Article 3 of the Moon Agreement is specifically for countries who are intent on growing their military might. So the article restricts state parties in their attempt to grow their military might from extending such into space. So space should only be used for peaceful purposes, and it restricts people from establishing their military bases, installation, and of course fortifications in space. The third one here is the United Nations must be informed. Now, not just the United Nations, but there is a particular office in the United Nations that has to be aware of any state parties' affairs in space, and that is the United Nations Secretary General. Now, when we move into the Registration Convention, we'll see how countries get registered, state parties get registered to launch into space. The fourth one here is information must be provided as stated in Article 5. You must state out information, what exactly you want to do in space. Is it to launch satellite cameras? What is the reason why you're launching into space? Those specifications must be issued out, including the locations, the purposes, and the durations. How long are they going to stay, or how long do they intend staying at space? Fourth is international regime. So when I was talking about the principle of resource exploitation as it relates to international space law, I made mention of the issue of international regime, where I said that we have some countries that have established their own personal laws that regulate their countries as regards space activities. But these laws obviously do not supersede international laws when there is a collision. So for example, the United States have theirs. We have countries like Japan that have theirs, and other countries like that have their own space laws or laws that regulate space for them at the international level. But obviously those laws don't supersede the Outer Space Treaties and obviously the laws that they have ratified to as countries. So finally, under this heading, we have common heritage of mankind. So this is in tandem with the principle of peaceful use of space. So whatever is done should be for the common benefit of mankind. Now, some scholars have interpreted this section, this Article 2 of the Outer Space of the Moon Agreement, to a very wide latitude, and so it is important that it is restricted. When they say common heritage of mankind, it is not that whatever is done should be spread out across. For instance, when I was talking about resource exploitation, I made mention of countries going in to mine the asteroids and then bringing back some resources from the moon and from space. Now, when those countries bring back those resources and then sell them off, it is not saying that in the process of selling all those resources, it should be the amount made or the profits that are derived from space to other countries. That's not what it entails. Rather, what it entails is that whatever is done, it should be for the common heritage of mankind, in the sense that it should not hurt mankind, it should not affect mankind negatively. That's what it means, which is in tandem with obviously the peaceful use principle, which I talked about earlier on. So in summary, we have been able to deal with the major content of the Moon Agreement of 19 1979. Moving further, we'll be talking about the Rescue and Return Agreement. As seen on the screen, we start. It was also once referred to as the Agreement on the Rescue of Astronauts, the Return of Astronauts, and the Return of Objects launched into outer space. Okay, so the Rescue Agreement was considered and negotiated by the Legal Subcommittee from 1962 to 1967. Consensus agreement was reached in the General Assembly in 1967, and the agreement entered into force in December 1968. The agreement, elaborating on elements of articles of the Outer Space Treaty, provides that states shall take all possible steps to rescue and assist astronauts in distress and promptly return them to the launching state, and that states shall, upon request, provide assistance to launching states in recovering space objects that return to Earth outside the territory of the launching state. So we're going to break this down so that we can all understand what this line of thought is all about. So from the first sentence here, it talks about the Legal Subcommittee negotiating Rescue and Return Agreement from 1962 to 1967, which is about 5 years. It shows how extensive they went into research and other things before they eventually agreed to this agreement. So eventually there was a consensus agreement that was reached by General Assembly in 1967, and the agreement was entered into force in 1968. Now, the contents of this agreement elaborate extensively on the provisions of Articles 5 and 8 of the Outer Space Treaty. Now, I'll go forward to show us what the provisions of Articles 5 and 8 of the Outer Space Treaty entail. As seen on the screen, we say that Article 5 of the Outer Space Treaty states that state parties to the treaty shall regard astronauts as envoys of mankind. When I was talking about resource exploitation, I did mention about this article, and I said that envoys of mankind has been substituted by some countries to mean personnel. So they're the personnel that are known to mankind. So wherever there is some form of collision, or wherever there is injury or hurt to any state parties astronauts, state parties of other countries are mandated to ensure that these people are rescued and returned back to their country safely and soundly. So if, for instance, an astronaut lands in another country's land or in another country's territory, that country, seeing that that person is an astronaut, has the duty of care to return that astronaut back to his original country. So as seen on the screen here, that's what Article 5 is basically talking about. The same thing goes for Article 8, which I won't go further to bother us on. Now, it says that that states shall take all possible steps to rescue and return astronauts in distress and promptly return them to the launching state, and that states shall, upon request, provide assistance to launching states in recovering space objects that return to Earth outside the territory of the launching state. So I've talked about that already. So Article 8, which I talked about earlier on, it says that a state party to the treaty on whose registry an object launched into outer space is carried shall retain jurisdiction and control over such object and over any personnel thereof while in outer space or on a celestial body. So when I talked about registration, the Registration Convention will be discussed on extensively later on in the course of this video. But as you can see here, the registry has been mentioned. So when you have registered an object to be launched into outer space, you shall retain jurisdiction and control over that object, and the personnel that you use, which is the envoy I talked about. Now you can see that it has been described as personnel, shall be under the control of the jurisdiction that launched it. Okay, so but this does not stop another jurisdiction or another territory from ensuring that wherever there is some form of, wherever a particular astronaut lands on another territory, that astronaut should be returned safely back to his home or to the state that launched the astronaut. So that's basically the major ingredient of the Rescue and Return Agreement. If you want to know more, you can go to the website of United Nations Office of Outer Space Affairs, where these things are discussed extensively. Furthermore, we are going to look at the Liability Convention of 1972. So what exactly is the Liability Convention all about? Now, we see here that the Liability Convention is an agreement that establishes the responsibility of a launching state to pay for damage caused by a space object. It was signed in 1972 and went into effect in 1972. The Liability Convention was signed in London, Moscow, and Washington on March 29, 1972. So we see that the Liability Convention is very essential. It's very essential. That's why it was signed and eventually brought into effect on the same year, to show how effective and necessary it is. But so far, we've had very few countries who have claimed liability for damages by one space object on another space object. So the liabilities convention more or less is not that useful, but at the same time it helps to restrict the activities of certain countries in space and to ensure that evasive action is taken whenever they launch their space object. So where there is a collision between one space object and another space object, the space object that is responsible for such a collision shall be held responsible, and appropriately damages shall be given out to the country that deserves such damages. Now, what does the Liability Convention do? I talked about settling claims for damages. It elaborates on Article 7 of the Outer Space Treaty. Now, what does Article 7 of the Outer Space Treaty talk about? It says that each state party to the treaty that launches or procures the launching of an object into outer space, including the moon and other celestial bodies, and each state party from whose territory or facility an object is launched, is internationally liable for damage to another state party to the treaty or to its natural or juridical persons by such object or its component parts on the earth, in air, or in outer space, including the moon and other states and other celestial bodies. So as I already stated, this is just a restatement of what I already said. So persons, okay, the state parties that are responsible for launching, and unfortunately where there is a collision, the state party that is responsible shall be liable to incur damages for such a collision. And yeah, that's basically it. So move forward to an example of a collision. Now this is a piece of space junk punched. It says a piece of space junk punched this hole into the hull of NASA's Solar Max spacecraft. Okay, so this is just one of the examples of a collision between one state party's spacecraft and another spacecraft's object. So we don't know the country that owns the object that collided with the spacecraft of NASA. Okay, we don't know the country. That's always a problem too. How will I identify a space object that's from another country? But that space object that collided was a particle. Like probably there was, I don't know, maybe in the process of launching into space, a part of it went out and then just was hovering over space. And this spacecraft collided with that little space junk. Okay, we call it space debris in space language, space debris. At that point, it's now a space debris. So it punched a hole into the hull of NASA Solar Max spacecraft and then caused this serious issue here, which can even damage the spacecraft itself. Now, we have seen I'm going to see how the extent to what such damage can do and what the interpretation of the damage in natural terms, in terms of human language. So we see that trash in space is more than unsightly. It's hazardous. At a typical orbital speed of 22,000 miles per hour, the plum-sized piece of space debris can hit another object with the same energy as a car crash on the highway, potentially putting a satellite out of commission. Even smaller pieces can damage spacecraft, so tracking them is mission critical for satellites and spacecraft that need to take evasive actions. So you see the extent to which that little hit can cause. It says it goes at an orbital speed which is serious speed. It says it can hit another object with the same energy as a car crash on the highway, potentially putting the satellite out of commission. That is making it to malfunction, making it out of its natural function. So that goes to show the extent to which that collision can harm a spacecraft or a space object. Now we see the Liabilities Convention. How does it work? First one here is that it relies on public pressure to enforce the legally binding award. So people have often said that international law is a toothless bulldog, that it doesn't have teeth to bite, that it's just there. It's just there. Unlike national laws, international law does not have teeth. To a certain extent, it's true, but generally, you cannot say that international law is toothless, because there are instances where international law has stepped in and has resolved issues that hitherto will not have been resolved. So we see here that it relies on public pressure. Yes, the public have to pressurize, and now the social media. So if one country complains of collision in outer space and then knows the country that is the cause of that collision and brings it up, the public will pressurize, and you know what that would do eventually. The United Nations, the ICC, International Criminal Court, ICJ, they will all step in to try and resolve the issue. So public pressure plays a huge role. Says that the results of any commission's findings, including the award, must be public. Whatever is done as some form of damages eventually must be given out in public, so we can know that yes, indeed, this thing has been resolved completely. Then a certified copy of the award must be delivered to the United Nations Secretary General. The Secretary General of the United Nations plays a very critical role as regards space activities, as seen over and over again. And finally, a claimant must pursue a claim by selecting one of two paths, either going before domestic courts of the launching state or choosing another international judicial body. So there are two ways to resolve the issue: either a domestic court or the launching state, the state that launched the object into space. Okay, and obviously that incurred losses as a result of the collision, or an internationally recognized judicial body shall be responsible for handling case or the matter and setting the damages. Then finally, we're going to look at the registration convention, which is very critical as well. We see that the registration convention was formerly known as the Convention on Registration of Objects Launched into Outer Space. It is an international treaty under the United Nations that requires all countries launching objects into space to register those objects with the essential registry. Private information like launch date, orbital parameters, and intended purpose, essentially creating a public record of space objects to promote transparency and accountability in space objects. So we'll try and break it down for better understanding. Now, we know what it was formerly called. It says that all countries that are launching objects into space must register those objects with essential registry. So it's not just about registering any object, it must be specific. Is it a satellite camera you're launching? What is the nature of the object that you want to launch into space? The United Nations must be well aware of it, and we have seen that the appropriate person or the appropriate office to meet the United Nations Secretary General. So we see that the object must be registered in the registry, central registry, and information that are necessary, like the duration, I talked about that earlier, the launch date, orbital parameters, okay, how large is the object, what's the size of the object, and important things like that, the purpose of the object, what is the necessity, so that you don't disguise it as a military base, which I talked about earlier on, and end up causing harm to other countries. Creating a public record of space objects to promote transparency and accountability in space activities. So this is second to our last point. And what are the key points about the Registration Convention? It says the purpose is to maintain a public record of all space objects launched by countries, aiding in space debris tracking. I talk about space debris. Space debris is like space junk, okay, where a particle of a space object gets out, or by reason of collision or something, there is debris moving around space, there is junk moving around space, there are particles of space objects moving around space. Okay, so it ensures that these kind of things are avoided, right? The business actions are taken to make sure the countries are launching, they don't end up launching into space debris and things like that. And then you can see collision avoidance and understanding of space activities globally. So second one is governing body. I mentioned the United Nations Office of Outer Space Affairs earlier on, and I was discussing in the course of our discussion. It's a very critical body, manages the registry and maintains the database of registered objects. You can go forward to look at it to know more about space activities and space law in general. That's really helped me a great deal. So it is in charge of those registrations and the object. And next slide, you see the country that registered, the latest country that registered, and how it is being recorded, how everything is being lined up. And then information required. The next one is the information required. I already stated this: the parameters, orbital parameters, the purpose of the object, and lifetime of the object, the launch date, and so on and so forth. Finally, legal basis. The Convention is considered a key part of the international space law framework, alongside other treaties like the Outer Space Treaty and the Registration Agreement. So it's a very critical framework. As I already stated, it's very, very important for the understanding of space law and the guideline for space activities. Finally, we'll look at this is like as of 11th of February. Okay, that's 4 or 5 days ago. This is the list of countries that intend launching into space, and this is the registry of the countries. So from what we have seen here, there is no Nigeria. So hopefully in the future, I don't know if Nigeria has ever gotten into this, probably once in 10 years, but I think we have to do better in that regard, because I haven't seen us here. As the giants of Africa, as we call ourselves, and we pride ourselves, we hope in the future that we will eventually get the opportunity to be among this list. You see United States are basically leading other countries. Russia are also here about 3 times. The United States are leading by the country now. So it shows how important space is, what could be developed and discovered as a result of activity that are going on in space. So this is a message to Nigeria and to the space faring and to the body responsible for space activities in Nigeria to make better efforts to ensure that we launch more into space so that our names can be listed out in registries like this and will be useful for those who are national researchers in space to know more about space activities. So at this juncture, we've come to the end of our lesson for today on the legal framework of outer space. I'm trusting that we're going to meet next week. Obviously, it's going to be a bang. I have a new subject I want to discuss on, which might be outside of space law, but which is going to be very, very critical to understanding of law and how it works internationally. So I really thank you all for watching up to this point.